Welcome everybody to House General and Housing. Today is Friday, thank goodness, March 20th. And we're gonna today do three things. We're continuing our exploration of institutional real estate investors' purchase of single-family residences. And we are then going to take a quick look at an amendment to H 772, which is the rental agreement legislation. And then we are going to have a little bit of testimony about a Senate bill, which is a Fair Employment Practices bill, but there are possibilities that we'll add to it, and we'll take a look at that. But returning to our first witness is H 607. Chris, I'm Mark Mahaly. I'm going to have the committee introduce itself to you. And why don't we start there? Debbie, you want to take it away?
Debbie Dolgan, I represent St. Johnsbury, Concord, and Kirby.
I'm Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Joe Parsons, Thompson, Groton, and Newbury.
Hi, Chris. Ashley Bartley, Fairfax, and Georgia.
Chris, I'm Mark Mahaly. I represent Calais, Plainfield, and Marshfield, and I'm the chair.
Emily Krasnow, South Burlington, Chittenden 9. Hello.
Hello.
Hello. Claudia Levant, the Royal Washington District.
Gail Pezzo, Chittenden 20, Colchester.
So Chris, I'm going to have you introduce yourself in a minute and tell us about yourself, just to set the stage. So we've taken up a bill that we've had here for a while, but haven't acted on or haven't had any testimony on. And it relates to private equity and institutional investment in the purchase of single and two-family residences. And we've taken a good bit of testimony. Some of it is focused on the problem, some of the bad things that can happen and have happened in other cities. I think that we realize that it's not as big a problem here yet as it is elsewhere, but it seems to be growing. And so rather than wait till the cow's out of the barn, we thought we'd take it up earlier. At the same time, our concern is that we know we need investment in Vermont. We need capital in Vermont to build houses, build rental units, et cetera. So we're trying to figure out how to regulate without being, if I might use a technical term, stupid. So that's why we were kind of looking around for people who do development, and your name came up, and that's how we got to you. So with that as a background, you want to tell us who you are and give us a little about yourself and tell us any thoughts you had.
Yeah, absolutely. So my name is Chris Snyder. I'm the president and owner of Snyder Homes. I'm a second generation home builder. My parents started the business in 1976, so we are in our 50th year of work.
Congratulations.
Yeah. And I had worked for a large home building company for a number of years but returned to Vermont in 2000. I have been managing our company since 2004 and purchased the company from my parents in 2014. So for the last 12 years, I've been owning and managing the business. Our goal as a company is to build approximately 30 homes per year and about 120 apartments per year. So we are somewhat providing housing for about 150 people or families per year, which is a relatively high number of units on an annual basis over the last, really since 2014, I'd say we've been achieving that result. In the last several years, we have increased our construction of apartment buildings as we partnered with UVM and with the University of Vermont Medical Center on providing employee housing or graduate student or staff housing for the college. So I have been personally involved both on the for sale and on rental side for this period of time, and but also been involved with larger entities, institutions on the housing. We generally build within we sort of joke, but 20 minutes of our office, which is in Shelburne. So if the property is within 25 minutes of here, we'll consider the potential opportunity, but further afield, not as motivated to work outside of our specific area. You know, thinking, and when I was asked to testify about this, I kind of started thinking about like, okay, what's going on with investment in homes or apartments in Chittenden County? And I'm going to speak specifically more to where my knowledge is. And we do sell probably 2 homes a year that are to an investor. Generally, it's a person or a couple that are buying. They have some investment that has generated some return, and they say, I want to go put my money into a rental property. And so they do that. And they see it as like an investment opportunity for them for the long term. I have not seen or heard or talked to anybody who wants to come in and buy more than 1 unit at a time. And it's very, I just couldn't envision. I mean, I've never been asked, and I don't think it makes a lot of sense for a large group to come in and buy like an entire neighborhood, one of our houses or 20 of our homes, because the individual investor is doing this. And so I look at it and I say, okay, well, what are they going to rent that house for or that townhouse for? And they basically are breaking even. It's only about the long-term ownership piece that they're paying down the mortgage on that property and they're getting principal. So there is some return on their investment, but it's not drastic. And that's because the cost of the house, if we were building a home that was at 300,000 and the rent allowed for it to be $3,000 a month, that would be one thing. But they're buying a $600,000 townhouse and renting it for $3,000. And so therefore, there's not a return, substantial return on their investment. And I would say that would be the case even for an institutional investor or private equity investor and buying single family homes here, is the rents would not actually allow for that entity to make money on an annual basis. It's more of this long-term ownership hold. So I hear the concern about we don't really have that problem here, but it's happening in other places. And I go, yes, that is true. And I do hear about that. And I understand the federal government is also participating in some discussions on this. But I don't see how our housing prices are going to come down drastically enough to be able to attract private equity investors who would be able to get a return on their investment in the current state.
Is couple of questions just right off the top. Do you think that, you said you sell maybe 1 a year, 2 a year. Are those people, I'm just curious, are they coming in because they're often they're facing, they're looking for an exchange? In other words,
so we saw one doing a 1031 exchange. The other one had an investment that paid out, that they all of a sudden had these additional funds, and they had a choice. They could either go invest it in the stock market, or they could go buy a house and then rent it.
Yeah, Gail?
What's a 1031?
It's when you sell real estate. Let's say you're a private party and you have an investment in a rental unit and you sell it and you might, let's say you bought it 20 years ago for a song and now it's worth a lot and you don't want to pay a huge capital gain. One way out of that is to just buy another unit. You plow it back into another unit. That is not a detailed.
But I get it.
But kind of you're taking your gain and putting it into 100% of that gain needs to go into the next deal. So it does happen, but it's somebody who doesn't necessarily need the funds from the gain for a day to day. But in this case, like the person got a 1031, it was enough funds to pay for the house. Well, now they're going to get rent paid
Right.
on a monthly basis, and so they're not necessarily going to get a return on their investment. They're just going to get a rent payment.
Right, it's a long-term investment.
Yes.
Another question, how do I explain this? So as the kinds of behaviors that we're seeing in other cities involve people buying up usually existing homes in poorer communities, and then there's a really elevated rate of ejectment, throwing the tenants out and and all of a sudden, and then they re-rent and all of a sudden what was a home ownership community turns into into a renter community, and the homes aren't kept up, et cetera. But so as people struggle to define what their target is, what they want to stop, as legislators do that, they tend to focus on trying to define what private equity is.
Mm-hmm.
One of our concerns is that we not capture the wrong thing. So if I might ask you, and feel free to generalize or not answer if you don't want to, where do you get the capital? I mean, obviously you have some debt in your projects, but where's the equity come from?
Me.
Okay, so you guys use your own accumulated equity,
Yes.
right? And when you build a project, is that your own? I assume each of your projects is its own corporation, right?
Yeah, they're separate LLCs.
It's separate LLCs.
Yeah.
Got it.
But
Right.
go
Oh,
ahead.
I was just gonna say, but, are you buying single family homes I know developing, but do you buy them as well?
No.
No, so he's not buying.
Right, he's not buying. it.
Right.
Okay,
I mean,
Sorry.
we bought a property that we are developing, and it has a single family house on it.
And thank you.
But like there's one house on it that will stay. Actually, it's going to go away. In this case, it's going away. But in some cases, we have seen where that single house on a larger parcel will stay, and the rest of the parcel is developed. And so that does happen where you might own that house and own it for a long period of time. But we're not out buying a single family house to go rent.
Well, thank you, Chris. I have the good fortune of not in the district I represent, but in South Burlington, of driving by a lot of the work that you've done. And I think you're owed a great deal of gratitude for, I know there's a lot of things the legislature, we're not here to discuss all the things the legislature could do that would be more helpful to people like you that you deserve. But thank you so much for all your development and sticking with us. And since you aren't one of the people that, would be captured in a bill like this, and really my intent, like our chair said, is to, your testimony is helpful, though, that someone in your position has not seen these actors come into at least your projects to buy up many of them at a time, et cetera. So it's still most of the testimony we've heard, I'm really struggling to find these people. So if you do happen to meet anyone that does meet this criteria and they're willing to talk to me or to the committee, you know, I would, you know, please let me know, but it's really helpful to hear at least that you haven't experienced it and you do understand the intent of the bill. But I again, just so much gratitude for all the housing that you've produced in South Burlington.
Yeah, thank you. Yeah, it's been a long time coming, and you know, people say, oh, you know, South Burlington really came together and really came up quickly. I have to remind them I started working on a project in 2012. So you know, it's not that quick in my world. It's quick in the building world, but not necessarily quick in the life cycle of the world.
Do you guys hold houses, or do you build them in units and then try to sell them quickly as you can, or do you hold?
So Snyder Homes is a build and sell company. I am also a member and owner in a number of LLCs that builds and holds. And where I would say is, you know, so I'll use UVM Medical Center as an example. They are a partner of ours in South Burlington City Center. If this bill was worked through the way that I have read that, then, or understand it, then they're an investor. And even though we're developing new, would they get trapped into this in that we have to offer it for sale because they're of a group that has more than $30 million in assets? And they also are an investor in more than 10 homes. And so when I read that, I was like, if that investment piece for the medical center was, you know, if they tripped that would be a downside to, you know, helping them create workforce housing.
So, two things. Yes, that would be a bad unintentional consequence, but they would not meet the definition under this bill because, well, two reasons. One, is the investments that they make right now, like Catamount Run and the other places like that, are not single family homes. Two, they're a nonprofit organization.
Yep.
They're
But
excluded.
what if that hospital wasn't a nonprofit?
So a hospital outside of Vermont wanted to buy up single family homes.
Yeah. I mean, maybe
Oh,
what
I
if
don't
what if
want
the
that.
world change? What if the world changes and these hospitals become privatized?
Yeah.
Yeah,
Okay.
absolutely. It is a good flag. I'm just using the UVM Medical Center as an
Yeah.
example. They would not trip or be caught up in this bill. But yes, if our UVM Medical Center became privatized and wanted to buy up single family homes in South Burlington, yeah, sure.
See, this is an interesting
But I
question.
personally would probably, I think that would kind of be a problem for me if that was something that happened. If a private hospital came in and wanted to buy up a bunch of single family homes, you know, I believe in workforce housing, but there also has to be housing for people.
See, this is an area we're really gonna have to think about hard because, well, first of all, I agree. I don't think it matters that they're a nonprofit because there could easily be for-profit partners in these kinds of things
Yes.
who are building new housing,
Yes.
which we want.
They can build it though.
Yeah, and building new housing, and their model is to build and hold. But what I'm hearing you say is at the moment, at least in Burlington, that's multifamily housing. Is that right?
Yeah, because that's what people can afford from, so the workforce and the employees and the staff can afford that level. I think if and our overall rent, if you look at the numbers, right, it's about what can they afford, but also what can we build for that price.
Right,
If we could go build 200 single family homes and and those staff or employees could rent a house versus an apartment, I think we would do that. It's just we can't build that house for the right price to make that work.
And I would love if we could build that housing and if UVM Medical Center could buy that for people and rent to them. I would love that.
Yep.
So I think that I really, I introduced this bill so that we could start a discussion and learn more. And I really appreciate you weighing in. And, now that we all have the connection with you, as we continue as the housing committee to discuss other things, I hope we may call on
He
you
was getting lunch. I don't know if
again
he's in the cafeteria.
to testify on other things. And believe me, I know that there are a lot more important things the legislature could be doing right now that might help people in your position. And our committee doesn't do land use policy in our jurisdiction. But we often have developers and builders telling us how we can do better. So I hope that please let us know if there are things that our committee could be helpful to folks like you as you continue to be a housing provider.
Absolutely.
Thank you.
Absolutely.
Thank you so much, Chris.
right.
Yeah, stay watchful of what we're doing
Yeah.
and see if you think we're screwing up.
All right. Sounds
Okay.
good.
All
All
right.
right.
Thank you
All
so
right.
much.
Thank
Thank
you.
you. Yep. Bye.
Bye.
We're still in session and we're waiting for Martin Lalonde, the chair of the Judiciary Committee, to come. So, but I don't think it's worth our going offline.
He just ran into his committee room real quick.
Maybe he was getting his paper.
Oh, okay.
Oh, that's what I said. I know him well now. I know Martin. Big South Burlington Day. We got Snyder, me, Martin.
Yes.
Chittenden County,
Yeah, I think single family homes will stay
And
help allow us, because if we go bigger, we'll miss people.
oh yeah, just single family.
I would have liked to hear more how they are successful in their workforce housing.
Yeah.
So that it could be, but if
We're waiting for Martin.
by the bill, so I
We'll
didn't.
be here any
No, I would love to, we're online, so chat. I would love to also, Sadia was just saying about workforce housing. I think that's something that at some point I'd love to really talk more about too.
Martin, welcome. We are online. We're just waiting for you here.
Oh, I'm sorry.
No. No, we just finished up with the last witness. So, we're back at this point. What we're on is A772, which is residential rental agreements and procedures, et cetera. And just to remind, the committee and anyone watching, 772 passed out of this committee. And at the same time, and it went through, Ways and Means, but, and it's now in appropriations. Am I right? Did it go to Ways and Means? No, it didn't go to Ways and Means. It's in appropriations. At the same time, because it involved so much in the way of judicial proceedings, we asked, the Judiciary Committee to take a look at it, and they've done it on a flyby. And in fact, taken quite a bit of testimony, really not quite as much as us, but from the major actors. And really appreciate that. Thank you very much for taking the time. And is there, and including a substantial amount of time with Judge Zone and Terry Corsones. And as a result, they produced the text of an amendment, which would be offered as an amendment to our bill on the floor. And their chair is here to talk to us about that. So Marty, take it away.
Yeah, and I'll kind of give you the higher level and I'll mention a few of the provisions and what we tried to do and definitely you should have Cameron do an actual walkthrough of the language because I could miss something and he won't miss anything. So we really went into this not really looking to weigh the interests of tenants versus the interests of landlords. That wasn't really our charge. It was to make sure that the court process could work and also make in a couple of ways, that the actual process is something the court could do, but also look at the resources of the court. Because I understood pretty early when I received the bill of draft 4.1 it was at the time. And after I did an initial amendment, I then started taking into consideration some of the concerns that the court initially talked about. Is I then had somebody come in, and Terry Corsones in particular, explaining the pretty significant resource issues that were involved in the bill as it was then. And that we were either facing a situation by prioritizing these cases that we would get further behind on the rest of the civil docket that the courts have, or we would have to put a lot more resources into the court system. So we were trying to work to resolve that issue. We also looked at places where it seemed that the discretion of the court was being taken away. We have to look at that kind of thing very carefully as well. So what we did is there's a few main things that we did in this. As far as court process, we looked at the show cause component of this. And
Let me interrupt. You guys all remember the show cause part was getting at the problem of the tenant that's causing, endangering or could continue to endanger the health and safety. Okay.
so
Sorry.
no, that's fine. Yeah. We replaced that whole process with something that's already in law, though we tweaked it a bit for unlawful occupants. We already have a process for expediting an ejectment of somebody who's an unlawful occupant. We made this whole process work for somebody who is their continuing occupancy of a unit would threaten the health and safety of the other tenants or people in the unit. So somebody would have to file a case, well, would have to have a termination based on that health or safety issue. They would file a case, and when they file the case, at the same time they're filing their complaint, they could file a motion for this expedited process, which is, as I saw it, works because it's a court process they already have, and is essentially the same timeline, if not actually a little quicker than what the show cause language was in there. So that was an important change.
Marty, can I?
Yeah, please. Yeah. Ask any questions.
Just my own impression, and please tell me if I've got it right. The difference, as far as I can tell, is from what we had, is besides being judicially better, is it's a little faster. And also, do you remember there were some testimony, some concern we heard that we had to be very careful not to create a situation where a landlord would just assert that somebody is posing a danger because of a one-time event that may not be occurring the way they say it is or something like that. And that I think they've improved it here in a way that isn't really a problem for landlords, in that it's not a one-time thing. You have to say that they're acting in such a way that their continuing presence would be a danger to the health and safety. And I don't think that for the kinds of things we're worried about, we've heard about, which is tenants who are selling drugs and being literally damaging units or stuff like that, I think that's a change that isn't gonna make it more difficult.
Right, and if there, I mean, if there was an instance of damage in the past, or perhaps could have been an instance of violence in the past, but there's not any indication that this is an ongoing threat if the person continues to be in the unit, then that expedited process is not available, and they would be in the process that is now 90 days instead of 60 days. That's one of the other changes that we made to accommodate the court and for them to be able to really get this done, having a reasonable deadline. So in any event, so that was one of the other places where we had some changes. Where there were places where it said that the court had to issue rulings in 3 days or 5 days, we changed that to promptly because, and the issue there is actually even a separation of powers issue. We're getting a little too close to the core functioning of a court, telling them when they have to rule on something.
For ruling, when they have to rule,
When they actually have to rule, yes.
as opposed to when they have to set a
Right,
hearing.
and that apparently doesn't cross the line.
Yeah.
Is my understanding.
Go ahead.
And Cherry, now that I've spent so much time in your committee this year, I learned a lot about how that worked with the animal cruelty bill, about directing courts and whether some folks may like to have certain timelines and other things, but what is realistic for the courts, and they advocate for that. And so I learned during the animal cruelty discussions that that's how it works. Whereas we may want something, but the courts, with the legislature can't just say X, Y, I mean, they can, but it's not feasible.
My impression was that we only did that. I mean, mostly the most important thing was when they have to set a hearing. But I guess, did we inadvertently at one point tell them when they had to rule?
Yeah, there were a couple of
Oh.
places still in the bill, but we changed that to promptly.
Thank
Okay.
you.
And,
That's
so,
why it's
yeah,
great to
yeah, so
Debbie, go ahead.
Well, I just had a question about the 90 days. It's no later than 90 days, so it could be 60 days
Right.
or maybe even 30,
Right.
depending on when that court is. I know our court system has certain days
Right.
already set that can be filled with these kind of situations.
That's
So you're
right.
saying it can't be any longer than 90?
Unless there's good cause, and I'll just give you an example of good cause. So the 90 days runs from the date of the complaint. But there's also needs to be service of that complaint. And if a landlord, they file the complaint, but they don't serve them for 60 days, I could see that the tenant would say, hey, I need more time. I'm supposed to be getting 90 days and I didn't know about the complaint, until 60 days after it was filed. So that's just an example of that there are instances where the court can extend that for good cause.
Well, there's a concern. I'm gonna state a concern, which sounds a little like bad faith, but I think I might as well get it out in the open. I know there's a concern that when you put words like good cause in, that you've just created infinite wiggle room, but I'm under the impression that the courts wouldn't treat it that way.
From the testimony, the chief superior judge, more than one occasion said that it's important to try to get these deadlines workable because we take them seriously. And we're not going to just use a good cause to get out of meeting these deadlines. So that's another reason to not put it on, is to listen to what they think they can do. And that's what we did. And it's significantly expedited for the breaches of a rental agreement, for non-payment, and then a separate path if it really is an ongoing risk. So that's, we did a couple other things in that court process, and I'll talk about confidentiality in a minute, but so as far as partial payment, this is one of the areas where we felt that just saying you shall only put into escrow the full payment really took away discretion from the court. And there are instances where a landlord and tenant can agree that a lower payment should be, or that there's rationale to have a lower payment. But what we did instead is the court has to initially order only full payment, but a tenant can make a motion and have to show and convince the court that they have a good reason why partial payment into escrow should be allowed. So that's one of those areas where we're really trying to preserve some of the discretion and the flexibility that we try to have to handle individual cases. The one other change is with respect to that is really didn't see, from our perspective, a reason to take out the ability to cure up until a time where there would be the writ of possession. So we took out language because it's actually it would have been an inconsistency with another provision in the statutes. So that's kind of I probably missed a few things here and there. I think one place where there was one other I'll mention right now is there was a change for when an answer has to be filed to 14 days. And we put it back to what is provided under civil rules. To have one exception for one kind of case is not a good idea. So it's just following civil rules. There would be confusion for attorneys who are doing this because they're always used to 21 days is what you have for filing an answer. So on the
That was just that's a consistency issue, you felt.
correct.
It would be confusing or,
Yes, there would be cases that would be filed after 14 days and would have to have additional court time to sort out why they did that. If it's 21 days, people know, they're very familiar with that. So there was quite a few pages related to confidentiality of the whole court process and the records. And our testimony from the court and really explaining how that would or wouldn't work is that it really would be difficult logistically to accomplish the way it was laid out. And would take, and that's where one of the places where significant additional court resources would be needed to have made that confidentiality part work. So we had a lot of discussions and really decided that a kind of a compromise that would still get at some of what the legal aid and others wanted was to do sealing of the case. And I'll explain that it would be at the end of a case and before a writ of unless a writ of possession was actually issued, that after the case is concluded, it would be sealed. In other words, it wouldn't be available to anybody except the parties and such. But both input from the legal aid, input from others was that wasn't a very workable solution yet. It needed more work. We need to do probably a petition process. We weren't quite covering the various scenarios of when it should be sealed or not. And the bottom line is that it needs more work. We didn't have enough time to do it. So we've taken out the confidentiality part. I'm committed to continue to work on the sealing part. In fact, I put in my first bill drafting request for next year. If South Burlington will have me back,
I don't know about that.
maybe I can even have it be H1. So
I've made other promises for H1, haven't I?
Oh, no.
so anyway, so I'm committed to continue because I think there's a path there, but we just ran out of time to get that right. So at this point, we suggested just taking out the confidentiality part because that really was one of the biggest problems for the court on being able to. So I think I covered most, but Cameron will correct me in walking through the details. Unless you have any other questions for why.
Yeah, this is the man. Ask him questions. Don't let him get away.
No, don't.
No, I have a quick question. After run to an
Debbie.
appointment. Is the version, because I just printed it out, so I'm gonna grab on the printer on my way out. Is the version that we have of this amendment what it would look like? Is it just, I don't know, an amendment like a regular amendment, or is it what 772 would look like with your proposed changes?
No, it's an amendment.
No,
It's a separate amendment,
it's
the
like
9
it's a
page
separate
separate
amendment.
amendment,
It's like not a
Okay.
strike all. It does strike some separate sections and replaces sections.
just so I can have
Right,
reference.
right,
Okay,
right.
thank you.
So one thing I did miss is in the trespass of a third party who's not on the lease and such, that there was an appeal process for small claims court, and that just doesn't work. And we took that out, and generally speaking, there's already can be just a normal process for taking this case up. So that was eliminated as well. I forgot to mention.
Oh, so
Debbie
I'm
and
sorry.
Debbie and then Gail.
Do we like the wording about the writ of possession shall, blah, 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 no earlier than 14 days after the writ is served?
Tell me which page.
Oh, that's on line 4 on page 8. I mean, I felt like we spent a lot of time on that wording.
It's on page,
Page 8, line 4.
Yeah, I don't think that's language that we changed. That's language I came over. So you'll see there's not all this language is our
Yeah,
new
yeah,
language.
yeah, I
It's,
get it.
it's, yeah,
I was
yeah.
just-
So that, yeah, we didn't touch that language.
Okay.
yeah, is that, you mean after
It's just-
the process, is this dealing with the process after judgment?
This is when you have a writ.
Yeah, there's been a certain amount of confusion about this. Do you remember?
I remember the
Okay.
confusion.
All right, okay. Okay. All right. Want to take us through as high a level as you can?
No question from you?
You answered it.
Oh,
You took
okay.
out the trespass and told.
Just the appeal.
Well, no, just the
Just the
appeal.
appeal.
The trespass is in there. It still could be a third party, can have a trespass from the landlord. And if they do trespass, it goes into the criminal justice system and there are appeal rights within that.
That's all.
No, my pleasure, my pleasure.
Can I, sorry, I should have said this earlier. I just want to thank you, as a chair. This has not been an easy topic in our committee, and I'm sure in just having chairs that are willing to come to a compromise, I think is really great. And so just thank you for your time. I know
No, thank you
committee's time.
for the good work you guys have done as well. And just to real quickly, Representative Vice Chair Burdick is also co-sponsoring this with me. And our vote was 7-0-4.
Good to know.
And I would imagine that most of those other 4, maybe not one, I imagine you could have had a 9-2 or 10-1 vote, but anyway. I'll stick around for a bit if there are any other questions.
Yes, thank you. I'm glad. That way we can keep asking you questions.
Sure. I'm gonna sit with the legislative staff. 10.
Good afternoon, Cameron Wood, Office of Legislative Counsel. I'm gonna be somewhat quick in walking through the exact language of the changes that you have. So the amendment is draft 7.1, and as was just mentioned, sponsored by the chair and the vice chair of the Judiciary Committee. So the first change is going to be here on this first instance of amendment, which proposes to strike out section 2 of the bill. Section 2 of the bill was when alternate service of process is issued in a civil case. So think about TAC orders is kind of how this has been described most frequently. If the individual can't serve the other party and they ask the court to receive an alternate service of process, the section had language that would make that alternate service of process last throughout the entirety of the proceeding. That section would apply not just to ejectment cases, but to all civil cases. And there was a lot of concern from the judiciary about that because again, it would apply to every civil case, not just an ejectment, but it would also, their concern was there may be reasons to have an alternate service of process at one point in a case, but not have alternate service of process at a later point in the case. So they took out that first subsection, which required the alternate service to last throughout the entirety of the proceeding. So they kept the second half of that proposal from this committee, which requires the court to rule on the motion. And this is where the chair mentioned it was 3 days, but it has been changed to promptly.
That's one area I just want to say. I'm sounding like I've been around here too long. This is a first cut. This whole bill is a first cut. We've learned a lot. and judiciary has learned a lot about landlord-tenant law. And so I think, to the extent I at least am interested in continuing this effort next term, and one area I'm interested in looking at hard is this whole service problem. Because it can be a significant problem for landlords. And one that I don't think, I think we could improve on, and I'm just not sure the best way to do it, but we will. Anyway, go ahead.
Okay, there's another piece of language that is not in this amendment. You won't see it because the second instance of amendment is striking out your entire section 3, which was an amendment to the entire chapter 169. So there was a corresponding technical change associated with the alternate service of process language, that because the committee is removing the alternate service that I just walked through, because that's being removed, the further technical change was no longer necessary. So I'm not going to pull that up and walk through it. The next change is, as the chair mentioned, was about the partial payment of rent. So when you get here to the bottom of page 2, you can see this is for the section where the landlord can file a motion to have rent paid into court during the ejectment proceeding. Subsection D, so there's still the strike through there on lines 15. So the court would obligate initially the tenant to pay full payment into court. The change is going to be on page 3, where you all in this committee recommended striking subsection G, which is where a tenant can file a motion, the defendant can file a motion to request a reduction in the amount paid. And so that was struck in your version. It's being unstruck here.
So does this mean, so both of you, Martin, you see, the effect of this essentially that the default now is full payment, but it's full payment unless the tenant, who's presumably represented, files a motion and has an affidavit that explains why. So it's kind of up to the tenant to show the need to do this, but
That's my understanding.
now the presumption is full payment.
Yes, that's correct.
Okay, all right.
Okay.
There's an addition of this new subsection I, which simply states that the parties can come to an agreement at any point and file their own motion to reduce the payment.
Okay,
The next change, so we get into property of the tenant remaining. All of this language is the same. The next change that is going to be from your version, we're moving into the subchapter 4, where you have the new ejectment process for a termination brought under 9 VSA 4467A or B. You all remember 4467A is termination because of non-payment of rent. 67B is termination because of some sort of breach of the terms from the tenant. So all of this language remains the same up until you get to the top of page 5. So this is this new 4862. This is the complaint being filed by the landlord, or now the plaintiff. And if you all remember, you added language in to say that if a tenant is being terminated for breach of material terms, which could include some sort of activity that's threatening other people, you required that the actual notice of the termination include an affidavit that sets forth the facts that document the reasoning behind the termination. Well, there was just a question or not about whether that document has to be included with the complaint. And so you can see this language right there on lines 4 and 5, stating that the complaint that's filed has to include a copy of the rental agreement if there is one, the notice to terminate, and include the affidavit that's required. So more of a technical change there than a substantive. And then the next real change is regarding the answer period. As the chair walked through and mentioned, you all had the answer being required in 14 days. Rules of Civil Procedure have it at 21 days. This change would remove the requirement that the answer be filed in 14. So it would default to the Rules of Civil Procedure, which is going to be 21. The removal of the cure period. So it's not language that I can point to on this page. I can pull it up if that would be helpful, but in the instance of in the trying to be quick with my walkthrough. There was period about you can cure up to the answer date that's been removed. So the parties can come to an agreement about how to cure and dismiss the action at any point during the case. The next change is going to be here on B1. So this is under this new subchapter for these ejectments. This is the standard time frame of when the hearing needs to be held. And as was mentioned there on line 15, the hearing must be held 90 days after the filing of the complaint.
Not later than.
Correct. Your report had it at 60 days after service of the complaint. So different time frame, different point of reference in time. So it's just a slight alteration of when the hearing needs to be held. The last thing I will comment, two more things I will comment on this section. The subdivision 2 here on line 16 was added, which states that the time frame doesn't apply when the plaintiff has possession of the lands or tenements or has received the writ of possession. So there could be a case that is being filed where the landlord already has possession or receives possession between the complaint being filed and when the hearing happens, or they've already received a writ of possession, but there are other remaining items that need to be resolved, or the landlord has brought the case under multiple different termination notices that were provided. And so this is simply saying we're not going to have this expedited requirement if the person already has possession of the property. The next change, this default language was just cleaned up by the committee. So I don't know, I need to pull up the other language. I don't think there was any necessarily significant change other than the motion here. Again, court ruling on the motion promptly on the default. So if an individual doesn't file an answer, then the individual can file a motion under a rule that currently exists. And the Judiciary Committee just wanted to make sure that language was reflective of the rule accurately and require the court to rule on the motion promptly. Now you get to this 4865. So as you all remember and you've somewhat discussed already, you had this show cause hearing. Show cause hearing is gone. In its place is this expedited hearing, which is based on an expedited hearing for an unlawful occupant, which already exists in the current subchapter for ejectment. So most of this language is just modeling it off the current language that exists in statute. Two things that I would highlight in this section for you is the language here on line 7. My lines and my pages mixed up. Line 7. A landlord can only ask for this expedited hearing if the defendant's continued occupation of the lands or tenements is threatening the health or safety of others. So as Mr. Chair, I believe it was you mentioned earlier, if you think back to the termination language in the residential rental agreement chapter, you don't need there to be an ongoing threat to terminate the rental agreement. It could be based on one instance, one act of violence, or one act of damaging the unit that threatens other people. You can terminate the rental agreement upon that. What the expedited hearing would require is that there be an ongoing threat if the defendant remains in the building. So that is a difference. And so just making sure you understand that distinction. If there's an ongoing threat because of the defendant's continued occupation of the dwelling unit, then the landlord could bring under this, and there would be an expedited hearing. And the other change or difference, I should say, is that this hearing would have to be within 21 days after the motion is filed. So pretty quick turnaround. That's different from what you all had in regards to the show cause hearing. The next change I'll bring you to is going to be on page 7. At the bottom, section 4866. This is just for costs and getting a judgment. If the court finds the plaintiff is entitled to possession, and then there was some language right there after the word possession that said like either by default or writ of possession, and it was limiting and unnecessary, so it was removed. So if the court finds the plaintiff is entitled to possession, regardless of when that occurs, whether it's the default motion that's filed or whether it's upon the expedited hearing, et cetera, the plaintiff shall have a judgment for possession or rent due. The next change is the bottom of page 8. So the rest of this language all remains the same. As mentioned, none of this changes. In regards to the 14 days, not earlier than 14 days, that mirrors what currently exists in statute regarding the writ of possession, so that's consistent. So then we get to the third instance of amendment right here on line 17, removing the appeal process for the trespass. So if you all remember, you've added trespass language to allow the landlord to issue an order against trespass under certain circumstances. There was appeal language there. As the chair mentioned, it didn't really fit with small claims, and there's no appeal rights under a normal trespass order. You as a landlord issue a trespass order, or I should say, if you as a property owner issue a no trespass order against someone, that person doesn't have appeal rights to that. So, just to remove that potential issue for the judiciary, and I don't mean the judiciary committee, I mean the judiciary itself as a branch, that was removed.
Right, Jenny.
I'm gonna go back to the TAC order. I'm just gonna use TAC order. So, we could make a motion to have a TAC order and make a motion for it to follow throughout the whole case.
Yes.
And a judge could decide to grant
Absolutely.
that.
And in fact, I've had several conversations. In the experience of certain landlord attorneys, those are always granted. In others, it depends. But it isn't automatic here. Do you happen to know, either of you happen to know whether or not under current rules before, Martin, do you happen to know whether under current rules before a TAC order is granted, does there have to be a certain number of attempts by the sheriff to serve if they're unsuccessful? Or is that just judge-made law?
I think it's rule civil procedure number 4, I think, if I'm not mistaken. I mean, I don't remember exactly what the.
But there is something, yeah.
There is, but there's also some room there to do something different than what's in civil.
Right, okay.
I mean,
This
that's
is
what
an,
we did in Representative Krasnow's bill. We did something a little bit different with respect to tax orders.
Yep, I'm a real judiciary veteran now.
I think that this is an area to work on. That's my feeling.
And then the last change, I'm not gonna bring the bill back up because the last change is just removing the confidential records piece as the chair mentioned. And that is all of the amendments.
Let's take a short break and then we'll come back and I'll ask you guys to give me a sense of where you are on this amendment. We're not talking about the bill, we're
Right.
talking about the
The
amendment,
judiciary amendment.
the judiciary amendment. Because remember, I'll get asked, where's the committee?